Welcome to Term Talk. I'm Jim Chance, Senior Judicial Education Attorney at the Federal Judicial Center. In each of our 8 to 12-minute episodes, we discuss the Supreme Court decisions from the most recent term likely to have the greatest impact on lower courts. Joining me today are Erwin Chemerinsky, Dean and Jesse H. Choper Distinguished Professor of Law at University of California, Berkeley, and Tara Grove, Vincent and Elkins Chair in Law at the University of Texas, Austin. Thank you both for joining us today. Today, we're going to discuss the opinion that's purported to have ended affirmative action policies at schools. Students for Fair Admissions versus Harvard College, in short form, consolidates actions by the same plaintiff against a private university, Harvard, and a public university, North Carolina. Erwin, as consolidated, the court considered whether the use of race as a factor in admissions violates the Equal Protection Clause in Title VI, and decided that it did. So can you lay out the facts and the issues for us, please?
Of course. I think it's important to put this case in historical context. In 1978, in Regents, the University of California versus Berkeley, the Supreme Court first considered affirmative action. It was splintered, and there was no majority opinion of the court. 5 justices agreed, though, that the standards under equal protection under Title VI are the same. Equal protection, of course, applies only to the government, but Title VI says that all recipients of federal funds are prohibited from discriminating on the basis of race. Justice Lewis Powell wrote the pivotal opinion and said that college universities have a compelling interest in having a diverse student body, that college universities may use race as one factor in admissions to benefit minorities and to enhance diversity, but that college universities cannot have a quota or a set aside of slots for minority students. 25 years later, in Grutter versus Bollinger, a majority decision of the court reaffirmed that. Justice Sandra O'Connor wrote for the court. She upheld, as the court did, a University of Michigan Law School affirmative action program. Once more, with the court saying, college universities have a compelling interest in having a diverse student body. College universities may use race as one factor in many in admissions decisions. And 7 years ago, in 2016, in Fisher versus University of Texas, Austin, once more the Supreme Court reaffirmed this principle and upheld the University of Texas affirmative action program. But the composition of the Supreme Court has changed since 2016. Students for admission brought the 2 suits you mentioned, one against the University of North Carolina based on equal protection, the other against Harvard College based on Title VI. And the issue before the Supreme Court was, may colleges and universities use race as a factor in admissions decisions to benefit minorities and enhance diversity? And the Supreme Court, in a 6-3 decision, held that college universities cannot do so. Chief Justice Roberts wrote for the court, even though the court never explicitly said it was overruling Berkeley, Grutter, and Fisher, that's exactly what the Supreme Court did.
So Tara, how did the majority analyze the issues in the case?
Just to follow up on what Erwin was saying, the court did not purport to overrule Fisher or Grutter or Berkeley, but those decisions had found that the consideration of diversity in admissions was in fact a compelling interest. And after this most recent decision, the consideration of diversity is no longer a compelling interest. So it sure looks like those decisions were overruled. What the Chief Justice said was that it's just too hard for courts to figure out what is diversity and for courts to evaluate college decisions in this way. And so it was no longer possible for the court to treat that as a compelling interest, which effectively ends the consideration of race in admissions decisions. Now, the court said a couple of other things as well. First, it said, we're not going to consider military academies in this decision. We're not going to decide whether military academies could potentially consider race in college admissions. And the other thing the court said was, we're not stopping students from describing their personal experiences in their personal statements, nor are we stopping colleges and universities from looking at those personal statements and considering all sorts of background experiences. So the court may actually allow colleges and universities to consider a wide variety of background, including background experiences related to racial discrimination. But the court also emphasized that colleges and universities cannot go through the back door and consider race in a way that's prohibited through the front door now. Now, what's interesting is that even though most observers, myself included, and Erwin as well, believe that the court effectively overruled Fisher and Grutter and Bakke, the court did not go through any of the stare decisis factors. So the court did not consider how erroneous those decisions were. They didn't consider reliance interests. They didn't go through any of the factors that the court had previously deemed important before getting rid of a precedent. So that's curious and something that the dissent pointed out. The final thing I'll say is that the court relied very much on a 25-year limit in what it perceived as a 25-year limit in the Grutter opinion. So in that opinion, Justice O'Connor had said, it's been 25 years since the Bakke decision. It sure would be nice if the consideration of race in admissions were no longer necessary 25 years from our decision, which has not yet happened, by the way. That would be the year 2028. But interestingly, both the majority opinion and Justice Kavanaugh's concurrence read 25 years not just as a hope or aspiration, but as part of the legal holding of Grutter, and said that there was a time limit on the consideration of race in college admissions, and the time had run out.
Well, Terry, you mentioned Justice Kavanaugh's concurrence. Tell us about the concurrences by Justice Thomas and Justice Gorsuch.
So Justice Thomas was the one justice who actually said the court has, the one justice joining the majority opinion who said the court has in fact overruled Grutter. But he went on to offer what he described as an originalist defense of the majority's decision, the non-consideration of race in university and college admissions. What's interesting is that the majority opinion did not do that. There was no effort to show, as a matter of original history, that colleges and universities, in fact, cannot consider race in college admissions. So Justice Thomas was alone in making that effort. And so it's curious that justices who describe themselves typically as originalists did not try to defend a major decision on originalist grounds. So the Justice Gorsuch's concurrence, which was joined by Justice Thomas as well, said the entire case should have been decided on Title VI grounds. All colleges and universities, whether they are state-run or privately run, get federal funds. So Title VI applies to everyone. And what Justice Gorsuch said is that Title VI bars the consideration of race in college admissions, even if there is a compelling interest. So he basically said that Title VI would create a categorical rule greater than the Equal Protection Clause, barring the consideration of race. Now, this is interesting on a couple of grounds. One, it goes against the prior case law that had suggested the Equal Protection Clause and Title VI should be interpreted to mean the same thing. And it also would create a categorical rule. And so no matter the circumstances, no matter the history of discrimination by a particular school, no matter what's going on the ground, no college or university could consider race in admissions.
Now, Erwin, Justices Sotomayor and Jackson wrote powerful dissents in this case. How did they see the issues differently?
Justice Sotomayor reviewed the history of racism and race discrimination in the United States. Said in light of this, there's a profound difference between using race to disadvantage people of color versus using race to remedy past discrimination and enhance diversity. She said that the effect of eliminating affirmative action would be, quote, devastating on diversity in college universities. She pointed to the history of California. In 1996, California voters passed an initiative, Proposition 209, that eliminated affirmative action by the state and all of its parts. And she pointed to the statistics that showed the dramatic decrease in the number of Black and Latinx students at UCLA and at Berkeley. Justice Jackson also wrote a powerful dissent. She pointed to the continuing intergenerational effects of slavery for the first part of American history. She vehemently disagreed with Justice Thomas' view that the Constitution requires colorblindness. And like Justice Sotomayor, she said, there's a major difference using race to benefit minorities, remedy past discrimination, versus using race to discriminate against people of color. There are such major disagreements between the majority and the dissent. Certainly on what I just mentioned, is it the same to use race to disadvantage minorities as used to benefit people of color? The majority and the dissent disagree over whether diversity should be regarded as a compelling interest. The majority and the dissent disagree over whether there should be deference to college and university administrators.
Erwin, what do you think are the takeaways for the lower courts?
I think it is clear that no longer can colleges and universities use race as a factor in admission decisions to benefit minorities and enhance diversity. But I also agree with something that Tara said. Chief Justice Roberts said it is permissible for college universities to look at an applicant's essay and consider how that person overcame racial discrimination, or how race was an inspiration in the person's life. But Chief Justice Roberts also said that college universities can't use that as a way of circumventing what the Supreme Court held. It's going to be a difficult line for college universities to draw as to when and how they consider race, and it's going to be difficult for courts to review. Also, it's important to emphasize that this case is only about admissions decisions. It doesn't concern recruiting students to apply or trying to get students to attend after they've been admitted.
All right, Tara, what say you about the takeaways for the lower courts?
So I think it's important to recognize that universities still have recruitment, scholarships, and other types of mechanisms to use to try to draw students from a variety of backgrounds to their schools. I think one of the next questions is also going to be, what other mechanisms can schools use to diversify their campuses? So right now there's a case pending about a high school in Virginia that uses geographic considerations in order to increase the diversity, socioeconomic diversity, and other types of diversity at its institution. So that it doesn't consider race explicitly, but the program was challenged on the ground that the purpose was to consider race. So far, the Fourth Circuit has upheld that program at Thomas Jefferson High School, and the case is probably headed to the United States Supreme Court. And that's going to be really important, I think, for a lot of public institutions and private institutions that see getting a diverse geographic and socioeconomic student body is really important. And whether some of the members of the court will call that sort of a backdoor way of considering race.
Tara, Erwin, thank you. So good to have you with us again. Thanks to both of you for sharing your insights today.